Mr. Bogosian, good morning.
Your Honor, good morning. May it please the Court. Paul Bogosian, representing Jason McCarthy, who is present in the courtroom. I've set forth 7 arguments on the appeal, and obviously I'm not expecting to get there. I would rest the brief for whatever doesn't come out. And I was thinking about really what to say about this. I think that this case really has come to have its own legs relative to an automatic license plate reader and whether or not there is a reasonable expectation of privacy that we as citizens have relative to automatic license plates.
So are you saying that the seizure or search begins at the moment they install the reader?
No.
Okay, so what are you saying then? When does the search start?
I think that the search starts if it's defined as a search as opposed to a seizure. At the time that a camera takes a picture of a license plate.
So the photographing?
Yes.
Not the searching of the database, but the initial photographing is a search,
Yes.
not a seizure, a search.
So when we drove over the bridge to get here, we were all, 6 of us were searched?
I would suggest to the court that at the time that the picture is taken and then transferred back to Chelsea and it is stored, at some point in time, the information that is derived from that plate concomitant with the picture.
So it's not just the taking of the picture.
Correct.
It's so we weren't searched when we came, but
Yes, correct.
but we could be. Is that the point?
You could be. And I'd suggest to the court that I think that this court's rulings are that the government's contemporaneous electronic monitoring of one's comings and goings in public places invades the reasonable expectation of privacy of a citizen. The court has previously held that GPS and CSLI, and I'd suggest like automatic license plate readers, are linked at a fundamental level, and that is that they all implicate the same constitutionally protected interest, a person's reasonable expectation of privacy in the same manner in that they track that person's movements. And that's exactly what occurred in this case.
Let me ask you, would it be okay in your mind if they had gotten a warrant before they asked for any report on the plate?
I apologize, I didn't hear that.
Would it be all right if, in your mind, would it be constitutional if they had gotten a warrant to search the database for any information on that plate?
I think that it would have been constitutional, obviously subject to my second argument that I've put forward to the court, and that is relative to a policy being in existence and whether or not, much like what we see in inventory policies, that typically these policies have to be in writing. If you're going to use them to search, you're going to use them to seize.
Let's tease out the GPS analogy.
Sure.
As we said a number of times, a number of courts have said in a GPS context and CSLI context, that when the government is able to access that data, it gives a mosaic, so to speak, of a person's life. It tells you where you go to services, who you meet with, etc. Because the cell phone is always with us no matter what.
Yes.
Here, the information the government gathers is persons on Cape or off Cape. So if I leave the Cape today, I could drive to Timbuktu, right?
Yes.
And the government's not going to know that. How is this like GPS when the only points of data is on Cape versus off Cape?
I think to answer that and relative to the theory that you just mentioned, it is not. I don't think that
Isn't that a problem for you?
Well, I don't think so. Unless it's continuously monitored through other automatic license plate readers.
Right, and the only thing we have now in front of us are the
Correct.
4
Right.
versus the network.
That's correct. But what I do find is that in Almanor, the court held that the pinging of a cell phone was a search, that the pinging and
And when I ping your cell phone, I want to know right where you are at that exact moment.
Right, that's exactly right.
Okay.
But it can be
And
anywhere,
It could
too.
be anywhere. You could be in your house.
Yes, exactly. And I think that here, the automatic license plate reader does the exact same thing, that at those 2 points specifically, the government will know where you are.
In one place. or
In
two
one,
places.
in one place, two places
Bridge.
potentially.
Bridges.
Potentially four places, depending on obviously how you travel and how you, what bridge you use. And the question is whether or not, on a privacy basis, the government should be allowed to have that information. What I've gleaned from the cases of Almanor and Estabrook and Augustine and Rousseau and Connolly and even Carpenter versus United States is that when you have, for instance, historic CSLI, the historic CSLI and the GPS warrants that have existed in those cases, the court has held that those are seizures and or searches, depending on what exactly has occurred. What I'd suggest to the court is that with historic CSLI, the closer you get to obtaining real-time location data of an individual, the more pronounced, obviously, the reasonable
Didn't we talk
expectation of
about
privacy is.
Didn't in Augustine and Estabrook, didn't we talk about limited data points not constituting a search?
What the court talked about certainly was, yes, and also the difference between telephone use versus registration, CSLI. Obviously, with telephone use, the government is only tracking and capable of tracking at the time that you receive or transmit a telephone. With registration, which is the reason why it interposed a 6-hour or less rule. Obviously, with registration, CSLI, now every 7 seconds that phone is on, the government is capable of tracking your location, where you are. That becomes even more effectively closer to real time, a real-time search.
I'm not so sure that helps you. I mean, every 7 seconds as opposed to only those occasions that you come over the bridge or leave the Cape and go over the bridge. You know, people don't leave their cell phones. All the students out there probably have them with them right now. If they're anything like my kids, and someone came down from another planet, they'd think that that's our oxygen. That's a lot different than a snapshot of the outside of a car every 3 weeks or so.
Justice Lowy, I'd answer it this way, that if the court is looking at this, and that is that because you only have 2 fixed points, there is not the intrusion. I'd suggest just the opposite. The mere fact that you have 2 points or even 1 point still is classified as an intrusion. It's a point of time in location where you are that the government should not have. If they're using that to track you, if they're using that, for instance, here, there was not only a real-time alert, which alerted by email and or text message, but there were 74 days of tracking of this car that were obtained even prior in time.
Can you draw a distinction between
Sure.
the real-time tracking that happened in this case, the so-called hot list,
Yes.
and then the database search?
Yes.
Would you say that one is more protected than the other as far as expectation of privacy?
I would suggest to the
Where
court.
the government mines in past information? Because what you run into are all the cases in our court and the Supreme Court where we say if a police officer could sit on the bridge in an unmarked car with a pad of paper and look for the Hyundai, you got a problem because that's what police officers can do. But mining the data is a different story. Can you address that?
Yes, I would suggest to the court that in Estabrook, that was the reason why the court created the 6-hour or less rule, where you didn't need a warrant beyond or less than the 6 hours, and that is because it was historic data. But to the extent that it becomes a real-time location analysis of where that person is, the court left in place, much like the registration CSLI, the court left in place the warrant requirement because it specifically.
But you've got real time out in the open with
You
a
do.
license plate
You do.
versus Almanor or other cases where you ping a phone and you find out the person's in their
Yes.
bedroom.
Yes, and in Carpenter versus United States and Almanor and Augustine and Rousseau, they've all stood for the proposition that the reasonable expectation of privacy and the constitutionality of what we have there needs to be protected in light of this new electronic technology that's coming out. Obviously, the court has created distinction and dichotomy between the old traditional surveillance and the methods used today where the practical effect.
Kylo helps you on that point, doesn't it?
It does. Kylo does directly. And where obviously the practical effect in restrictions that we once realized and expected would be there relative to a reasonable expectation of privacy in policing is no longer there. Now, even without any kind of effort, the police can actually obtain this type of data.
Does it matter that we're looking at license plates? I mean, license plates are, their very purpose, right, is to display who you are. And we have an expectation that the police are going to look at our license plates, right? They're going to see whether we have the inspection sticker on it. It's a public identifier, isn't it?
You have to have two, and you can't cover them up.
I think that respectfully is really the Commonwealth's position relative to Commonwealth versus Star. And I think that obviously what somebody knowingly displays to the public, you don't have an expectation of privacy in. But here what we have is we have the linkage. We have the numbers that are associated with a license plate, concomitant with the data that they're reaching out for. And then that data is being fed into the automatic license plate reader, and they're able to get a real-time location, a real-time alert that you're coming over the bridge. And typically, that is not what traditional surveillance was about.
Well, again, they could say, we have a drug case, we're going to put someone, in a car or wherever, at the rotary and look to see who's coming on Cape.
Sure.
That's possible. That happens all the time,
The
right?
practical effect of that.
That's just Alito's position, right? On the
Yes.
practical realities of traditional uses.
Yes, and the practical effect of it is that over the course of 74 days, I know I would suggest to the court that Your Honor hasn't seen the police sit for a 74-day period of time and or beyond
That goes to the distinction between real-time and
Yes.
historic.
Yes, real-time and historic.
And
That's
so
correct.
that takes me back to this idea of the hot list and the feeding of the information into the hot list versus the database search. You see a difference between those, correct? Or not?
I do see a difference.
All right, and so what would you say the best rule would be?
I think the best rule would be a warrant is required for both.
And do they have the required, so you'd need a warrant to put the license plate into the database on a hot list?
And or to retrieve.
Well, let's just start with the hot, say I have a hot list, I've got the stolen car, maybe somebody's missing, I want to put so I need a warrant to put the information into the system
I think that you need a warrant to be able
to get a generated electronic
get it.
beep?
Yes, and I apologize. I think the court is going through a protocol. I don't know if they put it in, I think they have to put it in first in order to get material
There's
out.
two different things, right? There's
Yes.
just the automatic collection that takes place, and you search that.
Yes.
And then there's the hot list where I've got stolen cars or whatever I've got, and I put that in and say, hey, you got anything on that?
Yes.
Or alert me. It actually sends an email, doesn't it, or a text
Sends
or
an email
something,
or a text or.
and says,
correct.
okay, it's going over the Bourne Bridge.
Yes.
With your doctrine, what happens with the transponders, Mass Pike tolls?
With my doctrine of a warrant, what happens?
What
I think-
would have to happen for the state to be able to use that without a constitutional intrusion?
I apologize. I don't know how the transponders work, but I'm just going to take a stab at it. I would suggest to the court that anytime you want to reach out for 74 days of somebody's past historic travel, then I think that obviously there has to be a reason.
Well, isn't there a distinction between what DOT does for cameras that are all over the state in the Mass Pike? Because the purpose of that is to monitor traffic and/or bill people who are traveling on the Pike. The purpose of the plate reader is to read plates,
Yes,
right?
But I think
Draw
that-
that distinction?
yes, and I understand that, but I think that here the purpose was law enforcement tracking.
Would you say that the stolen vehicles, you need a warrant for that as well?
I think that if the court, no. I think that if the court is tracking an individual, and I strike that, if the police are tracking an individual and they reach out for certain information to try to put together and chronicle that person's movements, I think you need a warrant,
Even if they're driving a stolen car?
even if they're driving a stolen car.
What about the mobile license plate readers? Do you need a warrant for that?
I think you do, again, if you're tracking a person's movements. And
So,
again,
So I'm driving down the road in my police cruiser, and I activate this device to let me read plates to see who's unregistered, who's stolen. Warrant?
No. There was
Why
a
not?
call, because I think that that is an isolated situation. Here, there was actual purposeful tracking by the police of an individual over the course of 74 days. No different than CSLI, no different than GPS. And the fact that they received a real-time alert is no different than GPS.
Well, it is different because, I mean, it's only identifying one place and it's only identifying the license plate crossing. I'm trying to understand, Justice Rufo draws a distinction in his opinion between if you agglomerate all of the different cameras around the state and you start plugging all that information in and digging that into that may be a different case. But here we've got two possible searches. One, the first time the camera takes the picture. And you're saying, I take it you're saying that society has a reasonable expectation that we will not have a picture taken of our license plate, at least by the police. Is
No,
that,
I guess what I'm saying is that
because
the
I
only
just
way
don't know where you're sort of arguing in different parts here, but I'm trying to understand, when does the search take place? And you need an objective, reasonable expectation of privacy there. I get your point that they've looked, what is it? I can't remember the times. They've done, how many altogether? They did 21 separate dates on this person, and they obtained 155 separate location records. Maybe that's enough, although all it does is say you've crossed the Cape that many times.
I would suggest to the court that Judge Rufo found the 21 dates as a finding of fact. And in fact, the testimony that was submitted by the log, if you count the ALPR log, there were 74 dates that it tracked this individual or this car. And not only that, did it track in 74 dates, this person, it tracked him even when he was innocent, when he wasn't even a suspect.
Tracking is an overstatement. It identifies him crossing the bridge. It's not, he's not being tracked. He's not being tracked to church, or he's not being tracked to his girlfriend's house if he's married to somebody else. He's crossing the border to the Cape.
And is he being tracked if it's just being collected?
Well,
Is that the moment of tracking?
I think that it's tracking if it's accumulating the data and somebody wants to reach out for it and utilize it in a
So
reasonable
if they just
suspicion
accumulate the data and don't reach out for it, that's what I'm trying to get. Is
Sure.
that okay?
I think
Is it
that's-
okay to accumulate all that data for a certain period of time?
I think it's fine to accumulate the data for a certain period of time. It depends on how it's going to be used.
And then you'd want a warrant to reach into it?
Correct.
So you're saying that the search is not the acquisition of the data, but the retrieval of the data?
I think so. I think it's the retrieval. And if you can separate the two acts, depends on the purpose. Obviously, if they put in the data for a specific law enforcement purpose, and then in this case, they retrieved historic data for that same identifying purpose, to identify the car, to track the car over a period of time. You see, what they did is they stated, even to a grand jury, that this car came over the bridge X amount of times, 21 times on differing dates, and therefore it was a drug courier profile or a drug dealer profile. So what they used these times to do was to profile the car in the reasonable suspicion calculus. So to that extent, as to when the search occurs, how it occurred, it's the compilation of the data concomitant with the purpose for which they were reaching out for it and what they applied it to.
Now, let me ask you one more question, if it's okay, Chief. Sure. Many states have a legislative scheme around this.
Yes.
And how it should operate, where it can be, what the police can do with it. Do you think that's appropriate in Massachusetts, or can this really be handled on a case-by-case, police department by police department policy basis?
I think it can be. I think it can be legislated. I think that, and I know that there are bills that have been pending for quite some time legislating automatic license plate readers. They haven't been passed. I don't think that they've been heard, and hence I think that we have the same. We have the issue here, and I would suggest to the court, in reading some of those bills keenly restrict the activity that was performed by the police in this case.
No matter what, there's a constitutional bottom to all that legislation, right?
That's correct. Yes, Your Honor. Yes.
All right, thank you.
Thank you for your time.
Ms. Sweeney.
Good morning. May it please the court, for the record, Elizabeth Sweeney again for the Commonwealth. The defendant has no expectation of privacy in the photos of his license plate on the Sagamore and Bourne bridges for 4 main reasons. First, it's a fixed point. Second, it's a public roadway. Third, there's no GPS, there's no tracking of the vehicle. And fourth, it's a photograph of the license plate only. The defendant has not shown any Fourth Amendment violation because there's no expectation of privacy in the photographs of his license plate.
All right, so let's stop there and say, let's say that's okay. That at that moment, no search. Now let's go to the next step, and I want to look in the database. What's the difference now?
You're looking at images that are of a license
You
plate.
see
of the
no
public.
difference between the accumulation and the and the dive into the
Absolutely
into
not.
the database.
If it was a security camera on the Sagamore Bridge and the police went to run, the footage from a month ago, it's the same thing.
Isn't it different because the purpose is different? The security camera that we see in every case we have nowadays versus this, which is purposeful. The police are doing this just to read license plates.
They're doing it for a security purpose to read license plates, which is a public in a public area.
In Jones, Alito said, in the pre-computer age, the greatest protection of privacy were neither constitutional nor statutory, but practical. Traditional surveillance for any extended period of time was difficult and costly and therefore rarely undertaken. So what they talked about in Carpenter and Jones is that if the police were allowed to do it in a traditional sense, it's okay. But when you enhance what the police can do, it becomes a search because it's an expectation of privacy. Isn't the accumulation of data in the search of the database that enhancement which raises expectations of privacy?
I would have to say no, because if this court looks at decisions like Connolly or Jones or Augustine or even Carpenter, the end result of what you're getting is information that can lead you to where a person lives, their political affiliations, who they associate with. And here we're just getting an image of Elizabeth Sweeney drove over the Sagamore Bridge. That's all you can tell.
Is the record limited to these 2 bridges and comings and goings, or does the record also include the 163 other cameras, license plate readers in the Commonwealth?
The issue in this case is specifically the bridge cams, the fixed point cameras. And the transcript of the motion to suppress doesn't deal with or address any other cameras in the Commonwealth.
What if we added to this the idea of, okay, 2 fixed points, we know you're on the Cape, we know you're off the Cape, but suppose now we know, in addition to that, we toss in some CSLI from your cell phone. What happens to that bridge information at that point, the license plate reader information? Is it still neutral, or does that enhance the CSLI or enhance the violation of privacy if you combine them?
I think that it's 2 separate issues, and with the CSLI, you're able to get so much more information, even more probably accurate information than the bridge cam. CSLI is very, very specific. The bridge cam, as the record reflects.
But what if the bridge cam leads you to say, oh, I better look at the CSLI?
There would need to be, to get CSLI, you'd have to show PC, and you would need something in addition to the bridge cam. So I'd say it's a small sliver of a set of facts that could lead to it. But again, what if you had a police officer sitting by the Christmas tree shop by Sagamore Bridge and observing the plates go over, and then you use that to get CSLI? There'd be no difference.
That police officer is not going to sit there for a year and look for my license plate, right? So don't you think if the police can search that database for an entire year and have my profile every time I come on the Cape, every time I come off the Cape, the times and the dates, you don't think there's an expectation of privacy in the citizens that that's not going to happen?
Absolutely not, because the information that you're getting doesn't rise to the level of a violation of your privacy. You're not learning any other information other than you drove over a bridge. You can't tell where you're going. You can't tell who you're going to see. You can't tell what you're doing. And that's what this court's concern is in Augustine.
But you're combining, it's back to what the accumulation. From what I understand here, you've got this number of data points, right? They do, and also they've got they're combining real time, right? They've got they're looking at historic data, they're also getting real-time alerts in a number of cases, right?
Yes.
So does that start to approach what that accumulation that Justice Rufo is concerned about, where we've got enough data here, where they're tracking him, and they're able then to do what Justice Alito is talking about, which is to have a cop start following him every time he comes to the Cape?
So I wouldn't describe this as tracking. I would just
I understand it's not tracking, it's just you've got this accumulation of data points, and I don't know if it's enough here, but it's not just the 7 of us crossing the bridge. They're starting to historically track this guy, and they're starting to put police cars on him when they know he comes over. I'm just wondering, does that get close to where you have a reasonable expectation that the police aren't doing that?
No, and I've talked with the district attorney about this issue at length, and if the cameras start communicating with each other, if we have a camera, for example, on the Sagamore Bridge, and then every single exit as you go up Route 6, all the way to the courthouse, and I could pinpoint precisely track where you are, then we're in a different area where perhaps we need a warrant.
But you don't need to do that.
But it goes to the EOPS cameras. These don't exist in a vacuum. These go to the Executive Office of Public Safety for that very purpose, correct?
For the purpose of
These 4 cameras don't exist in a vacuum. They're part of a system. And our rule is going to impact the entire system across the state. So we have to have our head in the sand to say that this case only impacts these cameras here. It doesn't impact facial recognition going forward and all those other things that you can talk about where there is an expectation of privacy.
The only cameras in the record, and the only cameras that I'm aware of, are the ones on the Sagamore and Bourne bridges.
But it's the jurisprudence which we have to worry about.
I understand.
Because, I mean, so are you saying you get, if it's only 2, it's okay, but
No, I'm saying if it's a fixed point camera where the only information that you're requesting and the only information that you're getting is that I drove over the Sagamore Bridge on October 2nd, you don't need a warrant for that. There's no expectation of privacy. But if you're going to request multiple cameras on the same day and say Elizabeth Sweeney drove over the bridge and she drove all the way up to Boston and get all these different pinpoint cameras where we turn into, say, London, then at that point, the court should say that we need to look at this and possibly get a warrant. But here, we don't.
You have 161 cameras right now, right? Is that what we have here? I think
The
there's something-
record doesn't reflect how many
Okay,
cameras
so
in the
maybe
state.
maybe that's one of the briefs that makes up what, but say
168 is in the brief.
so you have 168 cameras. Say, what, if they did the following here, I'm just questioning. If they asked to look at all 168, they're worried he's dealing drugs not only on the Cape but elsewhere. And they dug up all 168 and they tracked every time he showed up. They just, because we're combining real time, right? We've got cops following this guy as well.
Right.
I'm just trying to think, can they do that? Would that be a search?
If you're combining cameras.
If we took
that-
all 161 and we had police following him whenever it alerted one, that would be a search, right?
Yes,
So
absolutely.
it's the fact that they only checked 2?
Fixed points.
Mm-hmm.
It's not GPS tracking, it's not Connolly, it's not Jones, it's not CSLI, it's a fixed point camera.
Same
But-
answer on facial recognition, if it wasn't a license plate reader, if it was facial recognition reader?
Absolutely, you have no expectation of privacy if you're walking over the
So if
bridge.
they have a database that has facial recognition, goes to EOPS in Chelsea, it's some mainframe computer, and they tell me Gaziano has crossed the bridge 13 times in the last week, not a search?
Not a search. You have no expectation.
Maybe it isn't, but it's a long way from the privacy that citizens had in 1780 that I think Justice Alito might have been concerned about in the concurrence in Jones.
I would agree with that, and I think that, again, here, just guiding the court back to the issue that we're addressing today, the fixed point cameras on the bridges, just a picture of a license plate. You can't get a full picture of the car, you're not getting the picture of the driver. So
Let me
there-
stop you. You're talking about the accumulation of that data point.
Yes.
Is not a search
No.
or a seizure.
No.
It's just an accumulation of a data point that that's not protected.
It's not protected.
Okay, once it's in the system and I want a lot of data points or all the data points for the 100 days that it's been holding it, do I need anything at that point to ask for it?
No, because it's public information.
How is it public?
It's images of your
contained-
license plate as you drive over. There could be a police officer that sits there and writes down your plate or watches for me to drive over.
But that's the Alito, but the police officer, unless they have a photographic memory, unless there's some superhero, isn't going to remember 100 days back which license plates came. You're enhancing what police traditionally can, and that's what the justices have said constitutes a search.
But enhancement doesn't necessarily rise to the level of a privacy interest or efficiency.
It didn't say that in KO?
It doesn't, this isn't enhancing anything that the police have. They could sit there with a video camera and tape, take 8-hour shifts and film every car that goes over the bridge, or go up to, go to an event on Cape Cod and film every single car, every single person. This isn't a search, it's a public area. They're in the public.
But they couldn't necessarily retrieve the information as easily. What the technology does is the retrieval. It's not that hard to videotape. It's the ability to retrieve the information, which is greater.
And you retrieve that information, but what is it showing you? It's just showing you that somebody was in a public place, in a public area. It can't tell you if I went to work, if I went home, if I went to P-Town, if I went to
But in this
Nantucket.
case, what it's telling us is that this person came and left the Cape on the same day multiple times over a course of time. So that's a little bit more than just one ride over the bridge.
It is, and if you look at this court's decisions, going from, say, Estabrook all the way up to Augustine, Estabrook talks about the 6 hours of CSLI and what you need to get that information. This information we're getting is even less than that, and it doesn't rise to the level of Estabrook.
That
So,
might be the case for the immediate capture,
yes,
the hot list,
right.
as distinct from the database search. Then you're moving away from Augustine Estabrook, correct?
It does.
Don't you have a stronger argument for the immediate?
I think there is a stronger argument for the immediate collection of the data, the pinging or the sending to the officer's email.
Suppose we say that the immediate was fine, but the historical wasn't. In the context of this case, do you still win because of the probable cause that was found to stop the vehicle?
Yes, because they would have had that notification. There would have been no reason, no PC needed to get that information. The officer got the alert, and they stopped the car, and they did the warrantless arrest. And the court found, Judge Rufo found that there was PC to stop the car and make that arrest.
So what if there was a second point up in Truro? Would the fact that there now are two separate points change your analysis?
I think that it would be something that the court would need to look at, and what information that you were getting. And if you were able to put those points together and track individuals to the extent of Connolly, Jones, or Augustine. But we would have to look at that case. It's completely separate from what we have here.
The problem, of course, is that over the course of time, we can expect that there are going to be more of these. And the question I guess I'm trying to figure out is is it more than 2? Is it more than 4? When do we tell police that you need to have a warrant? When does the intrusion rise to the level that we say, okay, now you're learning, now you have enough data points that you're creating an intrusive mosaic as opposed to a less intrusive mosaic. It's not merely that you've crossed into the Cape, but now we know that you went to the Cape and you were heading towards P-Town.
When it rises to the level of CSLI level data, Augustine, Carpenter, when it rises to the level of you can tell where I go, who I associate with, religious preferences, political preferences, when it rises to the level of personal information being exposed.
So that's a lot of data points.
Yes.
So you're basically saying that you would have to then have a system more comparable to Beijing than to the Cape.
Yes.
In terms of that kind of extensive
Exactly.
capacity.
And if the state does go in that direction, then the court needs to look at that and take action to decide what we need to get that data.
Of course, I mentioned Beijing, it could also be London, which I think also has
It
that
does.
capacity.
Yes.
And there you could track somebody in terms of where they're going through the streets of London. You say it has to be analogous to the intrusion of GPS or CSLI, that's your measure?
Yes, when you're getting the information that you could get from a search such as GPS or CSLI.
What about Judge Young's poll camera case from the district court recently, in which he held that the police put a poll camera up to watch a house and watch the comings and goings and comings and going. So perfectly legitimate to put a camera up, I guess, but he held that that was a violation of reasonable expectation of privacy, that the government would be watching your house.
He
You think
did.
that has any bearing here?
I think that case, United States v. Moorbush, is distinguishable from what we have here. For one, it was in front of somebody's personal residence for 8 months, and the court noted that the police could manipulate the camera from their police station. They could zoom in on license plates. They could zoom in on people that were coming and going from the house. They could get a complete pattern of somebody's day-to-day life. And here, we don't have that information. It doesn't even come close. In order to change the camera or fix it, the state police, Brian Ignix, has to go and move the camera, manipulate it. There's no way to zoom in on plates remotely, and you're not getting, who's coming to my house later and, who I associate with and my friends. You're just getting Elizabeth Sweeney drove over the bridge. So-
Do we have, in the record, do we understand why they put the camera on the bridge? Do we know the particular purpose? I mean,
Yes, security reasons, Amber Alerts, Silver Alerts.
Okay, so Amber, security.
Criminal investigations, yes.
And does that play into our thought process here on the initial search? So they're concerned about Amber. So there's legitimate police purposes, obviously, for this. They're not just putting this up.
I think it supports, there's, again, legitimate police purposes. It's a tool that is assisting the Commonwealth with security on 2 main bridges leading to Cape Cod. And that's in the TRF 11 report from the state police. And if there are no further questions, I rest on my brief. Thank you.
Okay.